feminists characterize as men oppressing women. No, look at the historical norms. There was always an expectation that men serve women's comfort and make sure women are protected and provided for, to the expense of men themselves. This patriarchy is feminist patriarchy has never been proven.
It's another round of these are not facts, they're just things you made up to justify your feelings. The patriarchy isn't real, has never been proved. There's just historical norms where men have provided for women's comfort out of an overabundance of altruism and compassion. It's a take that is so staggeringly bad it can be debunked with just a single word: coverture. And since we're apparently unfamiliar with that word, I'll explain. Coverture is the legal doctrine in English common law that has governed a married woman's legal rights since the Middle Ages. It comes from the French, meaning either blanket or cover, because as far as the law was concerned, a woman who married ceased to be her own legal entity, and instead was covered by her husband. So William Blackstone, an 18th century legal scholar and jurist, wrote about coverture in his Commentaries on English Law in 1765. By marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband, under whose wing, protection, and cover she performs everything, and her condition during marriage is called coverture. Married women were not allowed to own property. Any property she owned as a single woman now became her husband's. Any wages or income she now earned as a married woman were similarly no longer hers, but owned by her husband. A married woman could not be sued. Any debts she incurred would be passed to her husband, but she was also not allowed to enter into any contracts nor make any purchases without her husband's approval and consent. If a married woman was injured, she could not sue, but her husband could on her behalf. Any damages he received were his alone. Barbara Lee Smith Bowditch, a prominent feminist and women's rights activist of the 19th century, wrote a brief summary in plain language of the laws of England concerning women in 1856, describing the impact of coverture in great detail. A man and wife are one person in law. The wife loses all her rights as a single woman, and her existence is entirely absorbed into that of her husband. He is civilly responsible for her acts, and she lives under his protection or cover, and her condition is called coverture. What was her personal property before marriage, such as money in hand, money at the bank, jewelry, household goods, clothes, becomes absolutely her husband's, and he may assign or dispose of them at his pleasure, whether he and his wife live together or not. Money earned by a married woman belongs absolutely to her husband. A married woman cannot sue or be sued for contracts, nor can she enter into contracts except as the agent of her husband. If she unites herself to a man, the law immediately steps in and she finds herself legislated for, and her condition of life suddenly and entirely changed. Whatever age she may be of, she is again considered as an infant. She is again under reasonable restraint. She loses her separate existence and is merged into that of her husband. She is absorbed and can hold nothing of herself. She has no legal right to any property. Not even her clothes, books, or household goods are her own. And any money she earns can be robbed from her legally by her husband. This covering also extended to children in the marriage. The legal custody of children belongs to the father. During the lifetime of a sane father, the mother has no rights over her children, except a limited power over infants, and the father may take them from her and dispose of them as he thinks fit. And far from providing wives with a life of comfort, husbands were under no obligation to provide for their wives at all. Neither the courts of common law nor equity have any direct power to oblige a man to support his wife. So much so that another English common law doctrine, that of necessity, was used to carve out exceptions for wives whose husbands abandoned them or refused to provide for them, by allowing them to break the law, to make purchases and incur debt in their husband's name without his express consent, in order to purchase necessities for survival, such as food. If a husband died, then his home and his wealth would pass to his wife. Just kidding, no, that's for his heirs and children. No, she was given 40 days to GTFO. Wives would be entitled to a third of the estate in order to support and provide for themselves so that they didn't become a burden on the state, which was called a dower, distinct from a dowry. If her husband had been wealthy with a large estate, she might be given a modest home on the grounds to live in called a dower house, but if she did, she gave up any rights to the dower. Coverture also meant that husbands had the right to use force and violence to correct their wives. Since he was to answer for her behavior, the law entrusted him with the power of chastisement, the same power he held over his children and his servants. A married woman did not even own her own body. And yes, that implies what you think it implies. A woman's body belongs to her husband. She is in his custody, and he can enforce his right with a writ of habeas corpus, meaning even if she tried to leave an abusive husband, he could force her to be legally returned to him, making her a prisoner under his jurisdiction, cementing a wife's position beneath her husband, not an equal, which was also made crystal clear in how English criminal law handled murder between spouses. If a husband killed his wife, it was simple murder, but if a wife killed her husband, it was elevated to the charge of petty treason, a far more serious offense of killing a social superior, the same crime as a servant killing a master. As such, was a betrayal of the obedience a wife owed her husband and a dangerous disregard for the social order. And this social order of subjugation of wives to their husbands baked into English common law became the basis for American law, leading to a number of Supreme Court cases involving coverture. In 1966, the Supreme Court decided the case United States versus Yazell, where the federal government was attempting to collect on a loan made to a husband by taking the wife's personal property. The wife argued that since Texas was still covered by coverture laws, and she was prevented from entering into legal contracts as her own legal entity, the government had no right to seize her personal property to cover her husband's debts. And the Supreme Court agreed, though in his dissent, Justice Black wrote, "The Texas law of coverture, which was adopted by its judges and the state legislature has now largely abandoned, rests on the old common law fiction that the husband and wife are one. This rule has worked out in reality to mean though the husband and wife are one, the one is the husband." This fiction rested on what I had supposed is today a completely discredited notion, that a married woman, being a female, is without the capacity to make her own contracts and do her own business. And yet, while claiming that coverture was largely abandoned, the court also recognized that 10 states, Alabama, Arizona, California, Florida, Georgia, Idaho, Indiana, Kentucky, Michigan, Nevada, North Carolina, and Texas all had coverture laws that limited the capacity of married women to conduct legal contracts to some degree. It's also worth pointing out that while this case made its way to the Supreme Court, Texas's legislature repealed this protection, granting married women general contractual powers and sole control over her own property. In Louisiana, in 1974, Joan Feenstra charged her husband with abusing their daughter. Her husband then mortgaged their home without her knowledge to pay for an attorney. She ended up dropping the charges and the couple separated. 2 years later, the wife learned about the mortgage and refused to pay, arguing that the state's head and master laws, another law based on coverture, that granted a husband the right to make decisions about jointly owned property without his wife's knowledge or consent, was unconstitutional. And again, this went all the way to the Supreme Court in the 1980s, and again, the court agreed that this was unconstitutional. And again, as this case was making its way through the courts, state lawmakers took steps to repeal this law in 1979. In both cases, we should point out these laws were not repealed in order to give women greater equity, freedom, and autonomy, but rather because coverture was inconveniencing and preventing collection of a debt incurred by the husband by taking the wife's assets. The 70s was also when the Equal Opportunity Credit Act was passed, preventing women from being discriminated against when applying for credit or being forced to apply in their husband's name. The notion that a wife's body belonged to her husband also wasn't challenged until the 1970s, with marital grape remaining legal in some states until the 1990s. The Feenstra case was then brought up again in another major Supreme Court case, Obergefell versus Hodges in 2015, which guaranteed the right of same-sex couples to marry. And part of the opposing argument was that allowing same-sex marriage was changing the, quote, societal meaning of what marriage is, with Justice Ginsburg arguing that marriage today is not what it was under the common law tradition, the civil law tradition. Marriage was the relationship of a dominant male to a subordinate female, and that ended as a result of this court's decision in 1982 when Louisiana's head and master rule was struck down. So not only was patriarchy baked into our governing laws, with civil and criminal law explicitly stating the expectation of subjugation of wives by their husbands, and enshrining their inability to own property, to make their own income, and generally be self-sufficient, forcing them to be at the mercy of their husband's providence, but a number of these laws were only repealed within our lifetimes. This is living memory, not ancient history. If you think patriarchy is a myth, then I strongly suggest you go pick up a history book. And maybe a new hat while you're at it.